Welcome back for another episode. Today I'm discussing the question, do I have to split my 401k in divorce? We had a nice gentleman come into our office who was extremely concerned about losing all of the money that he had saved up in his retirement account. And the way it works in the state of Utah is the state follows what's called the Woodward formula. That's based off of a case, Woodward versus Woodward, in the which the other spouse was entitled to their prorated portion of the increase of that 401k retirement account. So essentially, what that means is if you've been married for 20 years and your spouse has worked and started that retirement account, that 401k retirement account, at the beginning of your marriage, and then 20 years later you're getting divorced, you are entitled as a spouse to receive half of that retirement account because it increased the entire amount during the course of your marriage. Now, what if you were married and he had a previous 401k and he had acquired 100,000 and now the account's worth 300,000? Well, during the course of your marriage, it has increased $200,000. That means you would be entitled to half of the increase, meaning you'd be entitled to 100,000, not 150,000. I hope that makes sense. Sometimes retirement's 401k plans can be difficult to understand. There are what are called qualified domestic relation orders that need to be put in place, or quadros, and those need to be done by someone who knows what they're doing. Otherwise, they will be rejected by the 401k plan. So in essence, yes, you do. But having said that, in mediation or in negotiations, you can negotiate to keep your entire 401k. Usually you have to offset it by doing something else, perhaps giving them all of the equity in a house or a vehicle or something else that they really want in order for you to keep your 401k. There's always negotiation that goes on in divorce cases. So give our office a call if you have a Utah divorce case, 801-676-5507. Look forward to hearing from you. Thanks so much. Bye-bye.